Hello and welcome to the weekly analysis of Indian courts at LawBeat. I'm Sanya, here to take you through a quick round of important legal developments that happened across the country in the past week. So what made headlines in the Supreme Court of India? The Supreme Court has reserved orders in Justice V. S. Varia's plea challenging the order of Andhra Pradesh High Court, directing probe into an alleged conspiracy against Supreme Court and High Court judges. So what is this controversy really about? The judge had moved the Supreme Court against an order of the Andhra Pradesh High Court whereby an investigation was sought to be conducted into a private conversation between himself and a suspended Munsif magistrate. This conversation pertained to the alleged hatching of a serious conspiracy against the High Court Chief Justice and a senior sitting judge of the Supreme Court. The High Court therefore appointed retired Justice R. V. Ravindran to submit a report on the basis of an inquiry as to the genuineness of the alleged conversation in the pen drive, the persons involved and the undisclosed interests of the third party. It was against this order that an SLP was preferred in the Supreme Court by the judge. The All India Muslim Personal Law Board has opposed pleas which seek uniform laws related to divorce, maintenance, and alimony, stating that they are against the spirit of Articles 14, 15, 21 and 25 of the Constitution. Petition is already being heard before CJI S.A. Bobde-led bench. The petition by Ashwini K. Upadhyay seeks removal of anomalies in matters of maintenance and alimony in order to make them uniform for all citizens. A separate one seeks court intervention in matrimonial Muslim personal law, challenging Section 2 of the Muslim Personal Law Shariat Application Act, averring that it seeks to recognize and validate the practice of polygamy and nikah halala. Saket Gokhale writes to Attorney General for India, seeking initiation of contempt proceedings against ex-CJI Ranjan Gogoi for his comments about the Indian judicial system at India Today's conclave. Gokhale had moved an application addressing Shri K.K. Venugopal to invoke powers under Section 15 of the Contempt of Courts Act 1971 against the former CJI. Interestingly, Gokhale had stated that the ongoing contempt proceedings against Kunal Kamra and Rachita Taneja, who made derogatory remarks against the judiciary and the Supreme Court of India, accusing it to be hand in glove with ruling dispensation, found corollaries in the statements with Justice Ranjan Gogoi's. An update about this factum is that the Attorney General has rejected the grant of the sanction now, stating that he got the opportunity to see the entire interview and found nothing contemptuous in pointing out inadequacies of the judicial system. The Supreme Court has disallowed the grant of an extra attempt for civil services examination aspirants who could not take the examination in October 2020 on account of COVID-19. The court found no infirmity in the order by respondent authority, which was impugned before the top court. Court further observed that several other exams by the centre and state must have been conducted during the said period, and the case of the petitioner cannot be taken into isolation for the purpose of seeking additional attempt on the ground of COVID-19 pandemic. More so in the absence of any such provision under the rules. Let's now have a look at some of the judgments of the apex courts for the week. Consumer Forum has no jurisdiction or power to entertain a written statement beyond stipulated period of 45 days, Supreme Court has reiterated. Top Court referred to the observation made by a 3-judge bench in J.J. Merchant versus Srinath Chaturvedi, which was again reiterated by a larger 5-judge bench. Consumer Fora has no power and or justification to accept the written statement beyond the statutory period prescribed under the Act, that is 45 days in all. Court also relied upon MS Mumpy Timbers and Hardwares Private Limited and added that the settled law of both judgments stood good in law. Banks as service providers owe a distinct duty of care in maintaining and operating locker facilities, Supreme Court observed, while issuing guidelines for locker regulations. Court said that banks as custodians of public property cannot leave the customers in the lurch merely by claiming ignorance of the contents of the lockers. Court noted that banks as service providers under the earlier Consumer Protection Act 1986 and the newly enacted Act of 2019 owe a separate duty of care to exercise due diligence in maintaining and operating their locker or safety deposit systems. This includes ensuring the proper functioning of the locker system, guarding against unauthorized access, and providing appropriate safeguards against theft and robbery, among other things. Hindu widow can enter into family settlement with the descendants of her brother, that is on the paternal side, Supreme Court said, while upholding the family settlement entered into between a widow and her nephews with respect to the share inherited by her from her late husband. Let's now have a look at what the High Courts and other courts had to say this week. Bhima Koregaon violence accused Varavara Rao granted bail by Bombay High Court on medical grounds. A bench of Justices S.S. Shinde and Manish Pitale granted bail to the accused on the condition that he has to stay within the jurisdiction of the Special NI Court. He was also directed not to indulge in any activities or similar activities which led to the registration of the FIR against him. A Delhi Sessions Court granted bail to Disha Ravi in connection with the FIR related to farmers' protest and the alleged toolkit. Additional Sessions Judge Dharminder Rana granted bail to Ravi, observing that even though it was conscious of the difficult task to prove the prosecution case in the affirmative was the offence of conspiracy, it was virtually impossible for the defence to prove it in the negative, and that even the police made a conscious decision to arrest the accused, it could not be permitted to restrict Ravi's liberty further. The National Consumer Dispute Redressal Commission has reiterated that educational institutions do not fall within the ambit of the Consumer Protection Act 1986, and education, which includes extracurricular activities such as swimming, is not a service within the meaning of the Act. A husband cannot seek divorce claiming mental cruelty on the grounds that his wife does not do her household chores in the midnight, doesn't prepare his tiffin, and chews tobacco, held the Nagpur bench of the Bombay High Court recently. The High Court accordingly dismissed the plea of a man seeking divorce from his wife on these grounds. Madras High Court quashed an order rejecting request for conduct of Ram Janmabhoomi temple awareness. Court said that Lord Sri Ram was close to the heart of many in the Hindu religion. The single bench of Justice R. Hemlata of Madurai bench of Madras High Court has recently quashed the order which was passed by Assistant Commissioner of Police of Law and Order in Madurai city, rejecting the petitioner's request of conducting general awareness campaign regarding Sri Ram temple in Ayodhya. That's all for this week. I hope this was informative for you. Don't forget to hit the like and share button. See you next week.